Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech us, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath of affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Paula Gopi-Schoon and Senator Khadija Amin, both of whom are ill. Honorable Senators, I am not yet in receipt of the instruments of appointment for the senators who are to be sworn in, so I'm going to ask that we revert to this item on the order paper later in the proceedings. Honorable Senators, I have received the following correspondence from the Speaker of the House of Representatives. May the 11th, 2020. Dear President of the Senate, establishment of Joint Select Committees. At a sitting held on Friday, May the 8th, 2020, the House of Representatives agreed to the following resolutions. 1. Resolved, that in accordance with Standing Order 64-1C, the Representation of the People Amendment Bill 2020 be referred to a Joint Select Committee hereby established for its consideration and report by August the 31st, 2020. 2. Resolved, that subject to the concurrence of the Senate on the establishment of the Joint Select Committee on the Representation of the People Amendment Bill 2020, the House appoint the following 6 members to sit with equal number from the Senate on this committee. Mrs. Camille Robinson-Regis, MP, Mr. Fitzgerald Hines, MP, Ms. Shampa Kujo, MP, Mr. Colm Imbert, MP, Dr. Tim Gopi Singh, MP, Mr. Rudranath Indar Singh, MP. I request that the Senate be informed of these decisions at the earliest convenience, please. Respectfully, Bridget Mary Anisette George, MP, Speaker.
Bills brought from the House of Representatives. The Real Estate Agents Bill 2020 on the supplemental order paper in the name of the Attorney General. Papers, petitions.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Minister of Finance. The annual audited financial statements of Trinidad and Tobago Mortgage Finance Company Limited for the financial year ended December 31st, 2018, and the annual audited financial statements of the Trinidad Nitrogen Company Limited for the financial year ended September 31st, 2019. Thank you, Madam President.
Acting Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the names of the Minister of Social Development and Family Services and the Minister of Health. The ministerial response of the Ministry of Social Development and Family Services to the 13th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the prevalence of teenage pregnancy and the state's capacity to minimize the occurrence of teenage pregnancy and provide services and assistance to teenage parents. The ministerial response of the Ministry of Health to the 13th report of the Joint Select Committee on Social Services and Public Administration on an inquiry into the prevalence of teenage pregnancy and the state's capacity to minimize the occurrence of teenage pregnancy and provide services and assistance to teenage parents. I thank you, Madam President.
Urgent questions.
Senator Hussain.
Thank you very much, Madam President. To the Minister of Health, having regard to pleas by small and medium-sized business owners to be permitted to resume business operations, does the government intend to reconsider including these categories of businesses in phase 1 of the reopening of the economy?
Acting Leader of Government Business.
Madam President, I know it's not intentional, but I would like to be absolutely clear from the outset. It is not all businesses which have been closed on account of the COVID-19 regulations. Madam President, from the outset, those persons involved in agriculture, for example, agro shops, suppliers to agriculture enterprises supplying to supermarkets and so on, meat shops, mini-marts, supermarkets, hardwares, those things have remained open. In relation to hardwares, there was a change and then a reversion to the previous hours, but it's not all businesses which have been affected. Most, but many small businesses involved in the categories I've described have remained operational. Madam President, on Saturday, the Honorable Prime Minister listed 6 phases and provided details in respect of phase 1 and possibly phase 2. And what the Honorable Prime Minister has said, that in relation to the expansion of what has been allowed now, and I want to say that small and medium enterprises make up a significant part of the food establishments that can now reopen once they comply with the regulations, and in particular, once they do curbside service and they avoid congregation and serving and dining and so on. And the police commissioner is on record as setting out what are his expectations in relation to that. And the Prime Minister has listed a phase 2 for the period May 24th to June 6, 2020. But he has made it clear that this is contingent on COVID-19 numbers remaining down. And Madam President, I could deal with any country in the world, but right now in the United States, we see what is happening. And
Minister, your time is up.
I'm very grateful, Madam President.
Senator Hussain.
Thank you very much, Madam President. Madam President, having regard to all of the statements issued by the business chambers of Trinidad and Tobago, can the Minister indicate whether or not these chambers were consulted before the plan set out to phase reopening of the economy, please?
Madam President, I was about in my main answer to get into the United States business, and thankfully the time ran short, and it forces me now to stick to our business. Madam President, in mid-April 2020, the Honorable Prime Minister was very clear on the parameters by which the government will make decisions in relation to COVID-19. And he said the government will act on the basis of the science and on the basis of the advice available via the chief medical officers and the regional and international partners working with the CMO on this matter of COVID-19. I have greatest respect for my colleagues in the Chambers of Commerce. I was once chairman of the Employers Association, and never in my time as chairman of the employers body did I venture to advise a government, a prime minister, minister of labor on matters of science or medicine or even law, which was outside of my remit. The government will take advice from the chief medical officer, and what has been advised in relation to phase 1 is based on the medical and scientific information and advice available. And it comes with a caution that if people do not behave themselves in phase 1, phase 2 may never arrive. That is all.
Senator Hussain.
Madam President, is the Minister confirming that the government is not going to reconsider its decision to open these small and medium businesses, having regard to thousands of persons being unemployed and have not been able to access the salary relief grant as yet?
Senator Hussain, I won't allow that question. Next question, Senator Mark.
Thank you, Madam President. to the Attorney General. Having regard to the disclosure that there is a restriction clause in the Pariah Fuel Trading Company and the Aruba Spot Purchase Fuel Agreement, does the government intend to pursue legal action against the purchaser for breach of contract?
Attorney General.
President. Madam President, this question is premised upon a conclusion that is not before us. The question is specifically premised on the back of there being a breach of contract. I am not now in a present state to say anything about that. What we do know is that there was a sale to Aruba of the particular shipment. Anything beyond that is conjecture at this point, and therefore respectfully it is premature to answer any conjecture along this line.
Senator Mark.
Madam President, can the AG confirm this particular clause that is contained in the agreement for the sale of the 150,000 barrels of gasoline to Aruba, that anyone who the restrictive or the restriction clause, Madam President, can the AG confirm whether earlier export of fuel to Aruba had a similar provision as that which was?
I think we have the question. Attorney General.
Madam President, my honourable friend is searching for a scandal, and there is none. The lurching conclusions and exploratory remarks are driven by a political agenda of my friends opposite. The quite simple position in this has been advanced and stated clearly by the Minister of National Security and by the Minister with responsibility for energy, the Honourable Franklin Can. There is no scandal. Any attempt by the UNC to stir one is against the best interests of Trinidad and Tobago, and the population is searching for a reason why there is such a driven attempt to bring adverse consequences upon Trinidad and Tobago solely by the UNC.
Senator Mark.
Then may I ask the distinguished Attorney General, who says there's no scandal, may I ask him through you whether the government, on the basis of transparency and accountability, would be prepared to lay in this House the contractual agreement between Pariah Fuel Trading Company and that company in Aruba for public scrutiny and transparency.
Attorney General.
I thank the Honourable Senator for his question. I want to make this abundantly clear. As Attorney General, I've had no role in this particular arrangement or contract. This is simply because it is via a state enterprise that has been engaged in the course of business that it has been doing from the start of its operations. Secondly, I cannot, certainly without having seen the contract, speak to whether the contract contains terms and conditions of a commercial nature which would fit in within the arrangements of sensitive personal information at law, and therefore not being aware of the terms of the contract, not having advised on it in any way, I am certainly not in a position to undertake that responsibility. I am sure if the Honourable Member posed that question to the Minister of Energy, who has responsibility for these matters, that an appropriate and responsible answer can be given.
Questions on notice, questions for oral answer.
Acting Leader of Government Business.
Then there are 3 questions on notice. The government intends to answer all 3.
Senator Mark.
Thank you, Madam President. Question number 79 to the Minister of National Security.
Acting Leader of Government Business.
Madam President, the question raises 3 separate issues. First, it raises the issue of shootings directed at members of the Trinidad and Tobago Police Service. It raises the issue of deaths. In relation to the shooting, it raises the issue of shootings on duty and off duty. And in relation to the deaths, it raises the issue of shootings on duty. So I would say, Madam President, in relation to shootings directed at members of the Trinidad and Tobago Police Service, which my colleague describes as having an increase, my colleague does not set out the increase over what period, but I don't want to get into any confusion with him. But I would say that there's been a fluctuation in the numbers between the period 2015 to 2019. So if I can illustrate in relation to on-duty shootings targeted at members of the Trinidad and Tobago Police Service, for officers who were on off-duty in 2015, that number was 33. And it went down in 2016 to 12, up in 2017 to 48, down in 2018 to 36, and down in 2019 to 35. So you see, Madam President, between 18 and 19, there was no increase. And it's been up and down. In relation to on-duty officers, there was a spike in 2017 of 88, but it's now down to 8. So there's been a significant decrease in the shootings directed at Trinidad and Tobago police officers between 2017 and 2019. Madam President, in relation to the second part, the deaths of police officers in the line of duty, based on the information from the Trinidad and Tobago Police Service, there's been no officer killed in the line of duty since 2015. And Madam President, that can be attributed to a few measures. One is no doubt the Commissioner of Police's policy of one shot, one kill, the training that has been offered to officers, the improved training. 3, the psychological support that has been given, and the employee assistance in relation to dealing with things like stress, employee health, wellness, physical conditions, and those things which enable an officer to go out in the line of duty focused and physically prepared and able to do their duties. Thank you very much, Madam President.
Senator Mark.
Can I inquire of the Honourable Acting Leader, Honourable Senator, what was the number of police officers who would have died on duty in 2018?
Acting Leader of Government Business.
Madam President, I repeat, the information provided to me by the Trinidad and Tobago Police Service is that there has been no officer killed in the line of duty since 2015.
Senator Mark.
Can I ask the Honourable Minister how many police officers or men and women have been killed in the line of duty, Madam President, for the period 2015 to 2019? I know you talked about off-duty, but in terms of the line of duty.
No, Senator Mark, I won't allow that question. That has been asked and answered. Next question, Senator Mark.
Now, Madam President, we understand that the rate has been going down, the number of killings, that is, and further, the measures that have been taken by the police service. Can the Minister indicate whether these measures are the only ones that have been taken to address this issue, or is the police service contemplating additional measures to protect the men and women of the Trinidad and Tobago Police Service?
Senator Mark, I won't allow that question either. Next question, Senator Mark.
Question number 80 to the Minister of Social Development and Family Services.
Acting Leader of Government Business.
Thank you very much, Madam President. This question falls within the responsibility of the Office of the Prime Minister, for which we have a Minister of Gender Affairs. And Madam President, I would say that we recognize that domestic violence is a critical issue in the country, and the two most important measures taken in recent time, the Honorable Attorney General, in response to a question very recently, laid out the time frame for bringing to the Parliament the amendments to the Domestic Violence Act, critical amendments. That's one. And secondly, last week in this House, we passed the electronic monitoring amendment legislation, which seeks to improve what was there before. And a lot of the debate centered around the role of the monitoring devices in relation to victims and alleged perpetrators. And that would go a long way to minimizing the need for persons to be in shelters. Of course, we recognize that there will be times when victims would have to be placed in shelters for their own safety and for other reasons. So, Madam President, the government since 2017 has been able to outfit and get ready 2 centers for victims of domestic violence who need that level of protection. Unfortunately, Madam President, you'd be surprised to know there have been 5 tender processes, 3 of them by the Central Tenders Board and 2 by NIPDEC, to procure NGOs to operate these facilities. Successive governments have been very reluctant, given the nature of these facilities, to have public officers employed working in them, and have tried as far as possible to have NGOs do this service. And 5 attempts having failed, the government most recently has been working towards having it staffed by public officers in order for them to be operationalized. But at the same time, we've tried to minimize the need for it by bringing the domestic violence amendments and also passing the electronic monitoring amendment bill. Thank you very much, Madam President.
Senator Mark.
Madam President, can the Minister indicate, first of all, where are these centers located? Firstly, I'll come back.
Minister.
Madam President, I most reluctantly would have to say that I know that one is at St. Madeleine, former Caroni 1975 limited facility at St. Madeleine, but I would have to provide in writing the second one.
Senator Mark.
Madam President, in light of the fact that the government has taken a decision to employ personnel from the public service to run these centers, and given the crying need for these centers, can the Minister indicate what time frame he envisages, or the government envisages, to have these public officers recruited and to get these centers operationalized?
Minister.
Madam President, initially the government expected to have these places staffed by the end of March this year, but of course other matters have intervened, and as soon as the government is in a position to continue the recruitment process, the staffing would take place. In the meantime, the OPM and the Housing Development Corporation have been working to identify spaces which may be available in existing facilities to house the victims of domestic violence, while we take steps to staff these 2 facilities that have been outfitted and ready since 2017.
Senator Mark.
Can the Minister indicate whether the government has investigated what are some of the reasons or factors preventing NGOs from coming forward to take responsibility for the operation of these centers? Has the government conducted any inquiry or investigation to that effect?
Minister.
Madam President, I would say there are two issues. One is where those NGOs, in relation not just to domestic violence victims, but in relation to some of the other institutions for young persons, some of the NGOs which are faith-based NGOs have found that the services have become very complex and have gone way outside their remit in the services they provide in communities. That is one issue. But more importantly, Madam President, legislative changes have made it very, very onerous on some of these organizations, particularly NGOs and faith-based organizations, to continue to offer these services. In particular, some of the legal liabilities that are can now be attached to the operators and the officers and those involved. And many of them, and in this particular case, all of them, via the tenders process, have not been interested in providing these services.
Senator Ma.
President, whilst we are waiting the Domestic Violence Amendment Act and the operationalization of the Electronic Monitoring Act, can the Minister indicate to us what support and resources the government has provided to the NGOs to assist women who have become victims of domestic violence, particularly in this period of COVID-2019?
Senator Mark, that question is not allowed.
Thank you.
Next question, Senator Marks.
Question number 90 to the Minister of Education.
Acting Leader of Government Business. Oh, Minister of Education. 1027.
Thank you very much, Madam President. Madam President, the question is based on a false premise. Since 171 out of 176 former employees of UTT, or 97% of the total, have received their severance payments to date. The Ministry of Education has been advised by the University of Trinidad and Tobago, UTT, that on or about August 30th, 2019, the university was constrained to separate 176 employees on the grounds of redundancy following its restructuring exercise. The status of the severance benefits payable to the retrenched employees as of May 8th, 2020 is as follows. 1. The university has paid the severance benefits in full for 171 of the retrenched employees. These payments were made in two tranches. A, the first tranche of 75% was paid by the end of the notice period, November 2019, and B, the second tranche for the remaining 25% was paid between April 30th, 2020 and May 5th, 2020, subsequent to confirmation received from the Board of Inland Revenue, BIR, that the severance payments were exempt from tax upon inquiry by UTT. The BIR is processing the tax exemption applications in respect of the remaining 5 retrenched employees, 3 of whom were already paid 75% of their severance benefit. The 2 persons who have not yet received their initial tranche will receive this payment in the very near future, as there was an administrative oversight that resulted in the delayed processing for these retrenched employees. However, the Ministry has been advised that the accounting agency handling the severance package payments on behalf of the university is in receipt of their files for processing. Thank you very much.
Senator Ma.
Madam President, may I ask the Honorable Minister of Education, what were the reasons why the workers, 171 of them, were not able to receive their full severance benefits payments at the end of the retrenchment or redundancy process. Can the minister explain why the 100% severance payment was not satisfied?
No, Senator Mark, that question does not arise. Next question, Senator Mark.
No, I'm okay.
Yes.
Motions relating to the business or sittings of the Senate and moved by a minister.
Acting Leader of Government Business.
Madam President, in regard to the correspondence from the Speaker of the House in relation to the establishment of a joint select committee to consider and report by August 31st, 2020 on the Representation of the People Amendment Bill 2020, I beg to move that the Senate concur with the House of Representatives in the establishment of the committee and the following 6 senators be appointed to serve: Mr. Clarence Rambarat, Ms. Alison West, Mr. Robert Lehunt, Mr. Wade Mark, Mr. Paul Richards, and Mr. Deorup Timal. I thank you.
Honourable Senators, the question is that the Senate concur with the House of Representatives in the establishment of a joint select committee to consider and report by August 31st, 2020 on the Representation of the People Amendment Bill 2020, and that the following 6 senators be appointed to serve: Mr. Clarence Rambarat, Ms. Alison West, Mr. Robert Lehunt, Mr. Wade Mark, Mr. Paul Richards, Mr. Deorup Timal. Those in favour say aye. Those against say no. I think the ayes have it.
Public business, government business, bills, second reading.
Attorney General.
Again, I humbly repeat the call for a larger desk on the side, if it should please you, Madam President. It's extremely difficult to work with the limited podium. Madam President, I beg to move that a bill entitled An Act to Amend the Copyright Act, Chapter 8280, to give effect to the Marrakesh Treaty to facilitate access to public works for persons who are blind, visually impaired, or otherwise print disabled, and to the Beijing Treaty on Audiovisual Performances be now read a second time. Madam President, it gives me great pleasure to pilot this particular motion, this particular bill before the Senate this afternoon. Today is the day when, as it relates to one part of what we do as a society, we bring human rights into the copyright laws of Trinidad and Tobago, specifically for the visually impaired, print disabled, and other persons in this society, certainly in their tens of thousands, who are suffering from what is referred to as a book famine, meaning a scarcity of literature for people who just can't read in a normal way. And secondly, as we look to improve our economic potential for persons who have had very limited rights under our intellectual property regime for many years. And lastly, as we bring to light the focus of infringement being managed in a more aggressive way, which is more technologically specific. Madam President, today I start off by saying, what a coincidence that we have sitting amongst us one of the authors of this legislation, someone who has dedicated his life in some significant part, because he's done so much, to the pursuit of intellectual property, and I refer to and I pay particular homage to the Honorable Senator Anthony Vera, who has been an icon in the intellectual property arena for decades in this country. Despite the fact that he still looks a little young, he certainly is well known as having significant long pants in this arena, and it is a joy and a coincidence to have Senator Vera sitting in this Senate as an independent senator as we engage in this legislation. So let's get on with it. We are here to amend the Copyright Act by the Copyright Amendment Bill. Copyright is, of course, a property right. It is so, in fact, specifically labeled in the legislation as an acknowledged right of property. What is copyright? Quite simply, for people who don't know, copyright is an acknowledgement of the intellectual worth as it is divided into two separate parts as it relates to a certain category of people. And let me explain that. You have the economic rights, and then you have the moral rights, which go with a copyright. Your economic rights set out in the Copyright Act include the usual methods of exploitation, meaning the right to print, to reproduce, to etc., including your ancillary rights of broadcasting and whatnot. And then you have your moral rights, where you have the right to be known as the author, or referred to as the right of paternity, the right to ensure that your work is not the subject of derogatory commentary, etc. So there is that concept of copyright. We as a nation have come far away from Act number 13 of 1985. In that act, we had an old copyright regime. We, of course, Trinidad and Tobago, are members of the World Intellectual Property Organization, which is a subset of the United Nations. In that particular pursuit, and having joined WIPO in 1995 in a significant way, we adopted a number of conventions in Trinidad and Tobago. Of course, there is the core classic convention, which is the Berne Convention for the Protection of Literary and Artistic Works, which is an 1886 convention. We, of course, operated by adopting the Rome Convention, and that Rome Convention for protection of performers, producers of phonographic and broadcasting organizations is 1961. We, of course, adhere to the Agreement on Trade-Related Aspects of Intellectual Property Rights, otherwise referred to as the TRIPS Agreement. We, of course, also are participants in the WIPO Copyright Treaty, as well as the WIPO Performers and Phonographers Treaty of 1996. And recently, we have come on to accept the Marrakesh Treaty, which was brought into final form when Trinidad entered in June 2013, when we did the final act, but not in force until 2016 in September. And lastly, we have brought on the Beijing Treaty, which is the Diplomatic Conference on the Protection of Audiovisual Performers, which is final act in June 2012, but not yet in force, as we've only come up to 23 out of 30 people required. Why have I put that onto the record? Because those are the pieces of law which for a long time was standing on the books of Trinidad and Tobago under successive ministers without significant attention. Now I declare my interest. I'm a huge fan and lover of intellectual property. I had the privilege of pursuing it at master's level and find great joy in its contribution to GDP and in the novelty and cutting edge. Today I would like to acknowledge the hard work of controllers of intellectual property back to back, ending right now in the most effervescent personality of Regan Ascarali, who's the current controller. And in coming forward, I can tell you, as a government, we've had the pleasure of only last year dusting off the measures that we brought into place. I found it unacceptable as the minister with responsibility for intellectual property that we had not acceded to the Rome Convention, the Marrakesh Treaty, the Beijing Treaty, or the Singapore Treaty on Trademarks. And I'm very pleased to tell you that in the period September to October 2019, we acceded to all of those treaties. Why? Because at the same time, we have been transforming the Intellectual Property Office in Trinidad and Tobago, as the vision that I personally have, but will invite Cabinet to consider, is to move to an intellectual authority. We have taken the lead in the region with respect to patent cooperation, with respect to trademark cooperation, and with respect to copyright organization. We are near the final stages of moving our intellectual property office across to the government campus at the AG's office. We have already gone online with payments, with filings. We're using the intellectual property. Finally, intellectual property is receiving its fair point of focused attention by a government of Trinidad and Tobago. So let's get to the bill. I alluded to it at the beginning in introducing the three objectives. Effectively, we're doing three things. We're bringing to life the provisions of the Marrakesh Treaty, we're bringing to life the provisions of the Beijing Treaty, and we're bringing to life the technological prevention methods, which are anchored in both treaties, as well as in the copyright regimes of the WIPO copyright conventions, etc. And I think it's important at this point, Madam President, to put on the record the language coming from the two treaties. And I'd like to do that because it really could not be better said than via the preambles, in particular to the Marrakesh Treaty. The Marrakesh Treaty, to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled, and I stick a pin here now. You have heard me quote a case ad nauseum in this particular parliament. It's the case of Surat versus the Attorney General. I would like to stop and pay homage to Mr. Kenneth Surat, who has been the champion for visually impaired people in Trinidad and Tobago, together with the visually impaired persons, including the Blind Welfare Association, etc. His drive and passion to make sure that there is literature in terms of human right accessibility knows no bounds, and Trinidad and Tobago deserves to acknowledge him for his efforts in this regard. So here's what the preamble to the Marrakesh Treaty says. Recalling the principles of non-discrimination, equal opportunity, accessibility, and full and effective participation and inclusion in society, proclaimed under or in the Universal Declaration of Human Rights and the United Nations Convention on the Right of Persons with Disabilities, mindful of the challenges that are prejudicial to the complete development of persons with visual impairments or with other print disabilities, which limit their freedom of expression, including the freedom to seek, receive, and impart information and ideas of all kinds on an equal basis with others, including through all forms of communication of their choice, their enjoyment of the right to education, and the opportunity to conduct research, emphasizing the importance of copyright protection as an incentive and reward for literary and artistic creations, etc., aware of the barriers of persons with visual impairments or with other print disabilities or access to published works in achieving equal opportunities in society, and the need to both expand the number of works in accessible format and to improve the circulation of such works, taking into account that the majority of persons with visual impairments or with other print disabilities live in developing and least developed countries, recognizing that despite the differences in national copyright laws, the positive impact of new information and communication technologies on the lives of persons with visual impairments or with other print disabilities may be reinforced by an enhanced legal framework of the international level. And Madam President, those words coming from the treaty itself anchor what we are doing today as to one of the three limbs of amendment in the copyright laws, being the Marrakesh Treaty, to bring into effect the world of opportunity that our visually impaired and print disabled people, and what is print disabled? You can't turn a book, your eyes can't focus, you just can't manipulate the physical aspects of literature. These persons deserve their right, and therefore, in this bill, we seek, by way of a 3/5 majority, to amend that clear right to property that a copyright is, and to allow an exception for public purpose, for human rights purpose, to allow for the exploitation, and what does that mean? The printing, the reproduction, the adaptation, the derivative works, to come out of a literary or artistic work, as it is anchored in the Berne Convention and our Copyright Act, to allow for it to be adapted by a public entity, in this case, NALIS, which is an approved entity in this point, or such other entity as the minister may by order bring in, which has a public purpose, which is non-charitable, which is charitable and non-profit, and which, if it does charge, only does so in respect of coverage of costs. We allow these entities to have the right to adapt the works in carefully arranged methods, preserving the moral integrity of the work, but to extract the work, bring it into the visually impaired or physically impaired challenged regime, allow it to be put out by the entity that has authority for distribution, a non-profit entity, or NALIS in this instance, and therefore not only bring it locally into context, but internationally, because this bill seeks to also allow the pool of Marrakesh countries to share their works. And that's referred to in the banking that the World Intellectual Property Office offers by coming onto a harmonized arrangement for visually impaired. By bringing the Marrakesh Treaty into effect, we are therefore allowing for this to actually happen. What time is full time, Madam President?
3 minutes past 11.
Much obliged. Again, with the clock hidden. So, Madam President, I know I'm sounding a little bit impassioned, but I confess that I have a great regard for what we are doing here today. Madam President, the second limb is the Beijing aspects. And the Beijing aspects are to be found in the Beijing Treaty. The Beijing Treaty seeks to effectively manage the shortfall or shortcomings in the Rome Convention. The Rome Convention treats with, Madam Speaker, we recognize in the copyright realm that there are main rights to persons and that there are neighboring rights to persons. And the neighboring rights include the people that are just on the outside of the author of the work. And that includes the broadcaster, the performer, etc. The Rome Convention, which I've alluded to earlier, did not give the performers of certain works full economic rights, and certainly they had no moral rights. And therefore, the limitations in the world aspect of the Rome Convention had to be addressed, and that was what the World Intellectual Property Office did in birthing the Beijing Convention. In treating with the Beijing Convention, Madam President, let me put on record part of the Beijing aspects, and that will be found in, if I can find the Beijing before me, that will be found in the literature which has come out, which focuses effectively, Madam Speaker, Madam President, on the persons that are in that category of not having adequate treatment. And the Beijing Treaty on Audiovisual Performances, which is certainly something that we believe is something of benefit to Trinidad and Tobago, focuses upon, and I read here from the preamble to the convention, desiring to develop and maintain the protection of the rights of performers in their audiovisual performances in a manner as effective and uniform as possible, recognizing the need to maintain a balance between the rights of performers in their audiovisual performances and the larger public interest, particularly education, research, and access to information, recognizing that the WIPO Performances and Phonographs Treaty, done in Geneva on December 20, 1996, does not extend protection to performers in respect of their performances fixed in audiovisual fixations. And then it goes on to provide specifically national treatment for performers, being in that category of actors, singers, musicians, dancers, other persons, etc., in their audiovisual fixation, and I'll come to that definition in the bill, via broadcasting, which effectively should be in any means possible, via communication to the public, which is the springboard to any means of communication, including URL links or media links or streaming at the internet, and then giving in that national treatment the moral right, which did not exist previously, and certainly the economic rights in their fixed or unfixed performances. And fixed means anything recorded, for instance, in a DVD, etc. Unfixed refers to live performances. And the rights economically are right of reproduction, right of distribution, right of rental, right of making available of fixed performances, right of broadcasting and communication to the public, the rights of transfer, limitations and exceptions, etc. So the Beijing Treaty is something that is before us by way of the second aim. The third aim, of course, is the method by which you improve the remedies in civil law and in criminal law, in fact, if you look to the manner in which you circumvent rights. Now, that is to be found in Article 17 of the Marrakesh Convention and Article 15 of the Beijing Convention, where we need to make sure that we amplify the legal remedies so that devices which sidestep the security features of any work that is protected under intellectual property, be it in terms of the performer's work, be it in terms of the author's work, be it in terms of the broadcasting rights and the neighboring rights, etc., derivative works, these are usually in a technological world protected by certain device mechanisms, encryption codes, etc., and devices which actually allow you to breach those security protocols are what we seek to add in as the third limb to this legislation. Senator Vera, sitting as the consultant for the World Intellectual Property Organization, held 5 consultations, March 2nd, April 3rd, July 7th, August 19th, October 22nd, 2015, and in fact drafted the first version of the legislation with the CPC's department. We sent that legislation under my tenure to the WIPO, to their legislative department, to ask them to have a review. They came back with certain amendments to the work which was produced by the Vera Committee, and it is those amendments that are before us right now, Madam President. Madam President, I'd like to add for the record that the consultation included the following entities: Trinidad and Tobago Blind Welfare Association, persons with associated and visual impairment, School for the Blind Children, National Center for Persons with Disabilities, the CPC's division, Ministry of Foreign Affairs, Ministry of Education, Ministry of Public Admin, Telecoms Authority of Trinidad and Tobago, Ministry of Tertiary Education and Skills, Ministry of Health, Ministry of Arts and Multiculturalism, NALIS, National Archives, Ministry of Community Development, Ministry of the People and now Social Development, National Carnival Bands, Trinidad and Tobago Reprographic Rights Organization, Awesome Intel, Copyright Organization COT, TTCCO, Artist Coalition, Trinidad and Tobago Publishers, Production One, Hammersmith and Company, Paulin and Blah, Mayer and Company, and you'll notice carnival bands, etc., included there because our Copyright Act has a quite unique concept of something called a work of mass, which is born and bred in Trinidad and Tobago to recognize the entrepreneurship and rights which ought to exist in our carnival product as a work of mass. Our copyright law, of course, brings to life copyright regardless of fixation. In other words, then on the moment of creation, our copyright happens. So let's get to the bill in some of its structures. Let's go to the main benefits as we see in the legislation itself. Obviously, if we're looking to the Marrakesh Convention, we're looking to treat with the book famine issue, the scarcity of resources for visually impaired persons. We refer to them in this legislation as VIPs, and I think that that's a fitting term. We're going to give them improved awareness of the challenges faced, obviously, by making sure that the rest of the country comes up to speed with that and gives the copyright exception. We're, of course, giving improved availability of printed material, facilitating greater inclusiveness and participation of VIPs, providing VIPs with opportunities for professional growth. In the Beijing context, we're doing, as I've said before, the broadening of the rights from the moral and economic perspective that the Rome Convention certainly had difficulty with. And in treating with the Beijing Treaty, we're granting audiovisual performers, those in video, television, and films, such as singers, musicians, dancers, and actors, economic rights and moral rights in their audio-visual performances, which can either be fixed or unfixed. Fixed meaning in video, television, or film, unfixed meaning in live performances. Their moral rights, of course, the right to paternity, the right to not have the work in derogatory circumstances used. Those are being added for the first time. Obviously, it gives to economic development of Trinidad and Tobago in creating a category of remuneration for persons who were limited in that regard previously. Obviously, you still have the contracting freedom and the strengthening of standards. And the third limb being the technological protection measures. Again, we are making sure that we are WIPO Copyright Treaty and WIPO Performance and Phonograms Treaty compliant, and we are making sure that civil remedies in circumventing those protection devices are broadened and that criminal remedies be included as well. The bill before us itself is a mere 12 clauses long. If we look to the short title, of course, we have no real concern. If we look to the second aspect, we're acknowledging that a 3/5 requirement is required because of the copyright being a right to property. This is very relevant in the Marrakesh Convention aspects, because we're specifically treating with the lawful ability to not require the consent of the copyright holder where you are using it for visually impaired persons, VIPs, to create that answer for the book famine and other genuine human right objectives. So one could argue that that by itself, under the Surat case, did not require a 3/5 majority, but nonetheless, out of an abundance of caution, that is required. Madam President, we're looking to, in Section 3, to deal with the definitional amendments. I did have a quick chat with Senator Vera before we started today, and I'm aware that he has a few concerns in relation to some of the definitions, certainly with respect to broadcasting and also with respect to communication to the public. And what we're doing, I've actually sent off a request to WIPO as we speak to ask if they have any objections to the suggestions that Senator Vera made to me a short while ago before we started. So in Section 3, we're putting in a modified version of the definition of broadcasting, and that specifically comes from Article 2C of the Beijing Convention. In communicating to the public, we're again lifting from Article 2D of the Beijing Convention, and we're seeking to capture the broadest means necessary. I think that Senator Vera's concern can be captured so that we use the terminology of by any means, so that we're not technologically specific to wireless or non-wireless communication aspects. Infringing copies are also intended to be amended to add that audio-visual fixation aspect. Why? It was not there before. This anchors Article 7 and Article 15, respectively, of the Marrakesh and Beijing Conventions, and we've modeled it after Section 7 of the Singapore Act. In the definition of performers, we're broadening performers now for the first time, because these associated or neighboring entities under neighboring rights ought to have the economic potential, particularly as the novelty of our communication improves. One need only bear in mind that wonderful mark of genius called crazy legs in Trinidad and Tobago when you see the images come at us apace. We're looking at a definition of accessible format, audiovisual fixation. We borrowed from Singapore quite healthily. We're also looking to define an authorized entity. This is for the purposes of who can get the copyright exception, who can bring the artistic or literary work into visually impaired domain, and that authorized entity is NALIS under this law, under the new Section 12A. We've defined a beneficiary person in very tight circumstances so that we are careful as to the copyright as well as the moral right, the UN Convention right to the VIPs that require the success.
Attorney General, you have 5 more minutes.
Regrettably so. Circumventing technological protection, print disability, etc. All of these are coming straight from the convention. In Section 5.1, we're looking to anchor in the new audiovisual fixations and audio books, again, making sure that the copyright management is specifically labeled in that context. In Clause 5, we treat with the new 12A. 12A allows us to bring to life the Marrakesh Convention, that by allowing the authorized entity who has lawful access to effectively cause the adaptations with strictures as to moral works, etc., applying. We then make sure in Clause 6 to treat with removing some restrictions that we had in Section 18. And here's where we are now broadening the moral right to audiovisual fixation. This takes care of the loophole in the Rome Convention, which we now bring to life in the amendment to Clause 6. Clause 7 treats with the extent of the right, and we're adding that moral right aspect again in 19A, which treats with moral rights. We're making sure that we calculate the 50 years from when the performance was fixed, because as we know, the copyright has certain positions, life plus 50, it may be 50 years in this instance here, where we're looking at the performer's rights in the fixation of works. Clause 8 treats with an amendment to Section 21. We're dealing with the neighboring rights provision here, performances, recordings, broadcasting, etc. And we're dealing with authorized performances. And we are treating specifically here in those neighboring rights with the rights of performers as we bring to life the Beijing obligations that we are now signed on to. Clause 9 treats with an amendment to the Section 34A. Here is where we are treating with the circumvention devices. We're making sure that circumvention technology is not permitted other than in circumstances set out in the legislation, and therefore we bring that into context in this legislation. Clause 10 treats with exceptions to the offenses, which I've just alluded to, because obviously you can't bring to life Marrakesh and Beijing and not allow for the act itself to permit the exceptions to the law, and that's what the new Section 34C provides. Section 41(2) of the Act is brought together to treat with offenses, and here's where we bring the criminal side of the copyright law into parity with the civil aspects for technological circumvention methodologies. Clause 12 treats with an amendment to the mutual protection of rights, Madam President, as we treat with an amendment to Section 41A of the Act. And here's where we deal with the neighboring rights insertion. Madam President, the time that we have adjusted really doesn't give justice to the measures that one could speak to in terms of a human rights perspective or indeed an intellectual property perspective. I welcome the submissions of my learned colleagues opposite, who I am sure will agree that the time is right to deliver some of our most vulnerable citizens from the difficulties that they have prevailed under. Again, I salute Senator Vera for his work in this regime. I salute Mr. Kenneth Surratt. I salute the many members of the public society, and I thank the WIPO for its leaning into Trinidad and Tobago. Sometimes I think they live here. Sometimes I look at the extent of involvement that we have. Copyright, intellectual property rights are in safe hands in this government, certainly in this Attorney General, as we march the level of progress of our society, both on a moral and human rights perspective and an economic perspective, to performers for the first time, bringing to life things which just lay without focused attention for far too long. In those circumstances, Madam President, I look forward to the contributions of members, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Copyright Act, Chapter 8280, to give effect to the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled, and to the Beijing Treaty on audiovisual performances, be now read a second time. Senator Mark.
Thank you, Madam President. Madam President, it gives me pleasure, certain sense of honor and pride in speaking and contributing to this very important piece of legislation that is before this Honorable Senate, which is an act to amend the Copyright Act in order to give effect to the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. And of course, the Beijing Treaty on audio-visual performances that will afford greater legal protection and of course enhance economic rights through rewards, royalties to performers, including actors, comedians, dancers, and those expressing folklore within the definition of performers. Madam President, it was under the stewardship of a United National Congress administration back in 1997 that several pieces of legislation, I believe between 7 and 9, would have been tabled, debated, and passed in this Parliament. And that, Madam President, gave Trinidad and Tobago almost a leadership role in that particular area of intellectual property rights and the protection of same. I also want to say that it was the then Minister of Legal Affairs in the Pandey administration, the Honorable Kamla Prasad-Bissessar, who led the charge in piloting these pieces of legislation to strengthen intellectual property rights throughout all its areas of operations, Madam President. And Madam President, I want to also indicate that when the Attorney General spoke about the definition of the work of mass, which is identified in the Copyright Act, I would like to remind the Attorney General that that was patented for the first time by a United National Congress administration. We are the ones, Madam President, who made into law and patented for the first time the work of mass in this country, again under the distinguished leadership at that time of the Honorable Kamla Prasad-Bissessar. So I would want to make sure that these matters are put on the record, Madam President. Madam President, I would also like to say and to put on the record that Trinidad and Tobago was one of the first of 20 countries that signed and adopted, Madam President, not only the Marrakesh Treaty, Madam President, which facilitates access to published works for persons who are blind, visually impaired, or otherwise print disabled. But it was under the leadership, again, of the Honorable Kamla Prasad-Bissessar in 2013, as it relates to Marrakesh, as well as the Beijing Treaty for the visual performances. Again, adoption and signing of those two treaties came under that administration between the period 2010 to 2015, and more specifically, 2013, Marrakesh, and 2012, Beijing. I too would like to join the Attorney General in recognizing the excellent work executed by that indefatigable president, leader, and promoter of the right to knowledge, the right to access to information in an accessible format, Mr. Kenneth Surratt. I think that is important to recognize, Madam President. But I also want to indicate, Madam President, it was this same Kenneth Surratt who fought for protection for those citizens, Madam President, who were blind, visually impaired, or print disabled. And the first piece of legislation that was able to recognize the rights and protection against discrimination against blind workers, visually impaired workers, and print disabled workers, Madam President. It came under the Equal Opportunity Act of 2000. That same Surat, Kenneth Surat, was instrumental in bringing victory to those citizens. And Madam President, 15 to 20,000 of them, blind persons, will benefit from this measure when it is passed. And that is what the Honorable Attorney General was referring to when he talked about the book farming. These 20,000 citizens of our great republic will now be able to walk out of the darkness and see light virtually by being able to have access to knowledge, Madam President. And that is a fundamental human right, the right to knowledge. And that is what one of the treaties, Madam President, that we are debating today is all about. It is about allowing our workers, our citizens who happen to be blind and visually impaired and print disabled to be able to access, we estimate from the research that has been done, over 500,000 books, Madam President. Over 500,000 books. Madam President, do you know that there are over 300 million persons living in the world today with disabilities of one kind or another? And they were only 5% of that 300 million people were able to access books, unpublished books and works, Madam President. So this treaty that we are dealing with is going to benefit not only these 300 million citizens, but it will benefit the global economy, Madam President, by liberating those citizens so that they can make a more concrete and real contribution to economic development and establish their own independence. So this is not a simple matter. And Madam President, may I advise very early as well that Stevie Wonder, who you like, and I like, was very, very instrumental in getting this matter off the ground. Madam President, for 10 years, this treaty was being negotiated. 10 years. And it was the intervention of Stevie Wonder, who went to Geneva and told them he's not only visually impaired, Madam President. This treaty, the Marrakesh Treaty, and the one on Beijing will benefit a person like Stevie Wonder. He is both visually impaired and he's a performer. And Madam President, when he went to Geneva, he told those negotiators, contracting parties, state parties, that he would like them to bring some justice to the 300 million people. And he told them that if they did it, he would come back and celebrate with them. He went back, Madam President, when it was done, when it was adopted and signed. And Madam President, he sang the classic, signed, sealed, and delivered to that audience. Madam President, people went wild. They were dancing in the aisles for the first time because this was a major accomplishment for these 300 million differently abled, visually impaired, blind, and print disabled citizens of our universe. So, Madam President, we must understand that this measure that we are dealing with today, finds favor with us because we were and continue to be for the architects. We are for the protection of intellectual property rights. And Madam President, as it relates to the Marrakesh Treaty, whereas you normally protect singers, musicians, dancers, and other publishers and producers when it comes to protection of property rights, intellectual property rights. This one with Marrakesh is dealing with users, Madam President. Users. And that is why the whole convention, the United Nations Convention on Persons with Disabilities, you realize it was inextricably bound up with this Beijing Treaty because we were dealing, Madam President, with a human right, Madam President. So, Madam President, we would like to, as I said, congratulate all the players involved in this exercise. We know, Madam President, it was signed off in 2013. We also know it came into force through accession and formal ratification sometime in September of 2016. We know that the government of Trinidad and Tobago signed off in 2019 on these two matters. When I say signed off, they ratified, Madam President, those two treaties in 2019. And today, we are giving effect via legislative framework in order to allow citizens, first of all, those who are blind, disabled, visually impaired, that is, and print disabled. So, Madam President, this is really a red letter day for those 15 to 20,000 citizens, Madam President, who will benefit from this Marrakesh Treaty, Madam President, because we are dealing, as I said, with human rights principles, Madam President. Madam President, this treaty allows for the first time the right to read for the world's print-disabled people for all types of printed works and all formats. And therefore, it gives the libraries a key role in the successful implementation of this very important treaty, Madam President. So, this, as I said, Madam President, provides a lot of joy to citizens in our country who happen to be suffering. And Madam President, may I tell you, as we all become older in life, because none of us will remain forever young, we too are going to be faced with disabilities of one type or one kind or the other. So this is also impacting on us too in this parliament, because, Madam President, in the next 20 years, I won't be in this parliament. Many of us would not be in this parliament. And we don't know what disabilities we are going to be afflicted with. But you know what, Madam President? This treaty, this legislation that we are dealing with here this evening, today rather, this morning, will have a beneficial impact and effect on all citizens of our republic, Madam President, as I said, as we grow older in life, Madam President. Madam President, I also would like to indicate to you that when we look at the bill itself, it is also dealing with what is called the matter of audio-visual performances. And that, Madam President, is very, very critical to our artists, because as you would see in the preamble to the legislation here, Madam President, and more so here in the preamble and more so in the explanatory note, you will see, Madam President, some of the persons who were not included in the previous treaty, they now find their way. I don't believe, and maybe when Senator Vieira speaks, he will guide me on this one, whether comedians would have been involved as a category in terms of protection, legal protection, in terms of getting royalties for their works. Madam President, they are now included. Actors, Madam President, once they acted in a film, Madam President, or some television program, they got a fixed rate of pay. After that, Madam President, you went home. This legislation is providing those actors in this country, Madam President, with greater elasticity and space in terms of accessing economic rewards and royalties, Madam President. So it's not only comedians and actors, Madam President, but dancers are also going to benefit from this particular measure that is before us. Madam President, I also want to indicate that as we seek to protect our performers in this audio-visual performances treaty, known as the Beijing Treaty, Madam President, we would recognize, Madam President, that the copyright sector, the creative sector, Madam President, is a very critical sector in our economic growth, development, and transformation. And in this COVID-19, post-COVID-19 battle, economic battle for survival in TNT, this sector that we are protecting here, Madam President, to allow them to have a greater stream of royalties for their intellectual and creative endeavors, is going to trigger development, employment, economic transformation, if you will, Madam President. It will improve the status of the audio-visual performers in our country, Madam President. It will propel economic development in this country. Madam President, would you believe that a study done by one of our brilliant economists located in Tobago, Dr. Vanna James, Madam President, he did a piece for WIPO some time ago on the contribution of the copyright sector, Madam President, and the entertainment industry to our country, economy of Trinidad and Tobago, Madam President. And you know what the findings reveal, working closely with the Central Statistical Office? That 5% of this country's GDP, making up $8.3 billion, came from the creative industries, came from the entertainment industries. Madam President, when you talk about workers, Madam President, in terms of employment, Madam President, 5% of the employed citizenry in this country are also from that particular industry. You're talking about between 30 and 40,000 people who are actively engaged in that entertainment industry, who are making valuable contributions, not only, Madam President, to our GDP on an annual basis, but also to employment levels and opportunities for this country's development, growth, and expansion, Madam President. The big United States of America, Madam President, their contribution, the contribution of the entertainment, creative sector, and entertainment industry is about 9.4%. And we in Trinidad and Tobago, small Trinidad and Tobago, in spite of piracy, Madam President, still existed in our country. The literature is showing, the data is showing that the entertainment, copyright, intellectual, innovative, creative sector contributes 5% of this country's GDP as of 2012. And when we analyze the GDP of 2012, which was about $165 billion, we're talking about close to about $8.5 billion, Madam President. So this is a very important industry, the creative industry. And the protection that we are giving to our artists is very important to their own growth and development as individuals, Madam President. As I said, it will enhance their status as performers, Madam President. So this is a very, very critical situation that we are dealing with here, Madam President. And I hope, I saw in the explanatory note, Madam President, that the whole question of protection of culture and folklore and cultural diversity is also one of the tributaries or beneficiaries of this measure that we are dealing with today. That is the Beijing Treaty. But I also know that in Geneva, negotiations have been taking place for several years, Madam President, in Beijing, or not Beijing, rather, in that place called Geneva. WIPO has an intergovernmental committee, Madam President, on intellectual property and genetic resources, traditional knowledge, and folklore, called the IGC. And they have been in discussions and negotiations for several years, but they have not arrived at a place as we are today with the Beijing Treaty or the Marrakesh Treaty, Madam President. But, Madam President, when they arrive at that place in the not-too-distant future, we will be able to patent all our traditional folklore traditions, whether it's Husay, whether it's the Tobago heritage, whether, Madam President, it has to do with Ramlila, as the case will be, as a celebration. All of these folklore tradition, which is our culture, Madam President. It is we, that is us. It is our culture. And that, Madam President, is going to be very critical in the future for the generation of revenues. Madam President, I think the time has come. It is not in the legislation before us, but I call on the Attorney General to revisit the definition of work of mass, because there are still loopholes in this definition that allow people to come to this country, take photos of our mass, of our pan, of our Kaisonians and so on involved in the carnival, and particularly our mass, Madam President, and they sell it abroad, and we get no royalties for our creativity. So that is an area, Madam President, I believe that the time has come for the government to revisit that definition of work of mass and extend it so that we can have greater protection of that very inventive and innovative product in our country, Madam President. Madam President, I also want to indicate here that the time has come for the government of Trinidad and Tobago to look at putting it as a subject.
Senator Mark, you have 5 more minutes.
Yes, thank you very, very much, Madam President. Madam President, I believe the time has come for the government of Trinidad and Tobago to put as a subject, and if they don't do it because they are outgoing, we, the incoming government, will have to do it. Madam President, we must put as a subject on our curriculum innovation, creativity, and invention as a subject matter. Madam President, our young people, right, can get involved in the creative aspect of their own internal richness as it relates to talent in this country. Madam President, there are geniuses in our country, but because of the fact, Madam President, they are not being given the opportunity, and we are not really nurturing them as we ought to. We lose talents. Madam President, do you know in a place called Medellin in Colombia, they use the creative industry quite successfully in Colombia, where crime was out of hand in Colombia. And that creative industry got young people into real creative, inventive, and innovative activities. Crime in Medellin was reduced by close to 80% in a short period of time in a place called Medellin in Colombia. So it tells you, Madam President, the power of the creative industry. It tells you about the power of this thing called innovation and invention. It brings out the best in our young people if given the opportunity. And that is why, Madam President, I'm appealing to the government of this country to pay attention to putting on the curriculum of our school a subject, whatever name you call it, but it must capture invention, creation, and innovation. That is what it must capture, Madam President. Madam President, I know my time is racing ahead of me, but I also want to deal with the question of enforcement. The question of enforcement of these laws. We need to pay attention to enforcement, law enforcement, and the need for more training of our police officers in this particular field. And just as how, Madam President, today we have a gender violence unit in the TTPS in terms of protecting intellectual property rights in our country, we may need to establish a specialized unit in the police service that will really police through enforcement this particular matter of intellectual property rights in our country, Madam President. Whether we like it or not, Madam President, today in this country, we still have a lot of pirating of very important works of art and creative genius in this country. And therefore, you need greater protection from the authorities as it relates to that. Madam President, do you know that the entertainment industry in the world is valued over $1 trillion? That is the value of the creative industry, the entertainment industry, the copyright sector in this country. Over $1 trillion in the world, Madam President. So you could well imagine that if we give this thing the best shot, we can move from $8 billion as 5% of our GDP and reach America level of 9.5. We can do it, Madam President. So, Madam President, as I said, I want to associate myself and the United National Congress with this effort today. I want to thank you very much for the opportunity for addressing this chamber and to indicate that we will be supporting this legislation, and we'll, at the level of the committee stage, we'll ask the Attorney General to look at certain views that we have, but we are supporting the legislation. Thank you very much, Madam President.
Senator Vera.
Thank you, Madam President. Madam President, to stimulate the economy and for Trinidad and Tobago to thrive economically, especially in the face of the recent oil wars and a global pandemic, we must be able to tap into the creative abilities of all our citizens. This legislation will positively impact, empower, and benefit two groups in society: the visually impaired and performers. I should disclose that I was engaged by the World Intellectual Property Organization to assist with this legislation, and as such, I have a personal interest in seeing it come to fruition. In my private practice, I also act for a number of copyright owners, holders, creators, and collective management organizations, including COT and the Trinidad and Tobago Reprographic Rights Organization. And I was also a member of the committee to review the legislative framework for the management of intellectual property rights. Trinidad and Tobago, as we have heard, has long been at the forefront with up-to-date intellectual property legislation. Whether we have effectively used it, as we should have, is a different matter, but on the books, we have the right legislation. And successive administrations have recognized the importance of intellectual property and have generally been supportive. I want to thank the Honorable Attorney General for his kind words, and I recognize that he does have a master's degree in intellectual property, and as such, he understands this area better than most. And I want to put on record that he has been very supportive of IP and the progress of IP in Trinidad and Tobago. I can also say that I was also very proud of the leader of the opposition, the Honorable Kamala Prasad Bissessa, SC, when she, as Attorney General, put Trinidad and Tobago on the intellectual property map globally, when she convinced WIPO to allow for the creation and the protection of a new form of IP, the works of mass, as a derivative right. So the country is blessed in having very able and experienced leadership in this most important area of law, culture, and industrial practice. The bill treats with three aspects of copyright law. First, facilitating access to published works for persons who are visually impaired or print disabled. Secondly, extending the rights of performers by including audiovisual works, as opposed to performances only fixed in sound recordings, and now covering all live performances, not just oral, and this is A-U-R-A-L, as in sound, not oral, mouth. Oral performances. And thirdly, ensuring adequate legal protection and effective legal remedies against pirates and those who would seek to circumvent protection technologies. So that's the core of the legislation. Before drilling into the specifics, it might be helpful to put copyright and related rights into context, as they permeate every aspect of contemporary society. Copyright is the foundation upon which the information age is built, and it is a critical component for the film, music, fashion, and entertainment sectors. Copyright is a property right that subsists in literary and artistic works, which are original intellectual creations in the literary and artistic domain. And they would include books, computer programs, works created for the stage, musical works, audiovisual works, works of architecture, photography, maps, and sculpture. Publishers and printers, newspapers and magazines, libraries and universities, the music industry, film and television, radio station and broadcaster, art galleries and museums, including the paintings, the many beautiful paintings hanging throughout the walls of Parliament. All the software systems in your mobile phones, your laptops, your personal computers, your designer clothes and fashion accessories, the music and the movies we love, all are covered by copyright, which, as the word implies, is a right to prevent others from copying protected works. And that protection is the incentive needed for the creators and business to develop and exploit the things we all need, love, and enjoy. Now, the impetus for this legislation is two treaties. This is not the time or place to consider how treaties are negotiated and how treaties are performed. Suffice to say, a treaty is an agreement between states which is binding under international law, and it is up to each state to ensure how they are correctly applied. The need for treaties has intensified as the world's interdependence has intensified. Treaties have become the most frequent means of creating international rules and standards. They form the basis of much of modern international law, and quite often, they generate a moral perspective for the community of states and peoples across the globe. Intellectual property rights are protected internationally because of treaties, and in particular, the copyright treaties administered by WIPO, which build on, complement, and dovetail with other international treaties and conventions. So as I say, the source of this legislation flows from the Marrakesh and Beijing treaties, and I will treat with each in turn. The Marrakesh Treaty seeks to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled. Now, one of government's responsibilities is to find ways of making citizens more productive. And it has also been said that the purpose of the law is to ensure that all citizens, including the disabled, should have the same rights and opportunities as everyone else. So by empowering the disabled, we make for a richer, more inclusive society. One of the great unsung heroes of history was l'Abbé Lep, a humble priest who ministered the poor and the destitute of Paris in the 19th century. He was very concerned about the deaf, and he developed a sign language for them to communicate. And that sign language has spread rapidly throughout the world. The result was that the hearing impaired were liberated from their world of silence. Before that development, it was assumed that because they could not speak, they lacked intelligence, the deaf lacked intelligence, and they were treated as less than human. A couple years ago, there was a report on 60 Minutes about an architect, Chris Downey, who, though he had lost his sight, firmly believes that he has actually gotten better at his career because of his disability. Among other things, this gentleman has since come up with new technologies for the visually impaired as relates to architecture. He has also been able to create and design smart buildings that he would not have been able to conceptualize had he not lost his sight and gained these insights and new awareness. As he put it, while he could no longer see buildings and spaces, he began hearing them. He could hear the architecture and feel the space. And so it turned out that instead of his career being doomed by blindness, it enhanced both his professional abilities and him as a person. As he came to realize, the creation process is an intellectual process. It's how you think, and sometimes you just need new tools. So today the world enjoys and celebrates the contributions of Andrea Bocelli, Ray Charles, Stevie Wonder, James Joyce, and our own blind calypsonian Almanac. We even recently ordained in Trinidad and Tobago a blind Catholic priest. So by empowering the visually impaired to be their best creative selves, all society benefits. Essentially, the Marrakesh Treaty requires us to have a limitation or an exception in the copyright law for the visually impaired, which will allow authorized entities to reproduce, distribute, and to make available literary works into accessible formats for the benefit of those who have visual impairments or who are otherwise unable through physical disability to hold or manipulate a book or to focus or move the eyes to the extent that would normally be acceptable for reading. Think, for example, Stephen Hawking. He could not turn the pages of the book. A lot of research, consultation, and thought went into determining which organization would best serve as our first authorized entity, as that organization would be in charge of providing the appropriate services necessary to the print disabled and copyright owners. In particular, being able to make accessible format copies of works, being able to supply those copies to the beneficiary persons, being able to ensure that only beneficiary persons or other authorized entities would get hold of and be able to use those copies, and being able to maintain proper records when making and distributing copies of works whilst respecting the privacy of beneficiary persons. So under the proposed amendments, authorized entity means an entity that, in relation to providing the services of education, instructional training, adaptive reading, or information access to persons with a print disability, fits into one or more of the following categories. It is authorized or recognized by government as providing such services on a non-profit basis. It is a non-profit organization that provides such services as one of its primary activities or institutional obligations, or it is a governmental institution that provides such services as one of its primary activities or institutional obligations. And NALIS, the National Library and Information System Authority, meets all the necessary criteria. Now, we looked at other organizations, Blind Welfare Association, the Tourist Foundation for the Blind, and the National Center for Persons with Disabilities. And when any of those organizations can provide the required functions, meet the given responsibilities, and have the resources and capacity to ensure that accessible format copies are only reproduced, distributed, or made available for the benefit of beneficiaries, they too can be included in the list of authorized entities. The law provides for that. But given that authorized entities have to be named in the statute, it was felt we would be conservative, and so NALIS was chosen as the first. Now, one of the most heartwarming aspects coming out of the consultations was the support that was given by the Trinidad and Tobago Reprographic Rights Organization and BioTT, which represents our local book publishers. Because even though they will lose remuneration and royalties because of the proposed exception, they felt it was a sacrifice worth making in the national interest. So they deserve to be commended. I would also like to recognize Mr. Regan Ascarali, the Controller of the Intellectual Property Office, for championing the rights of the visually impaired for many years, and for ably representing Trinidad and Tobago internationally on the implementation of both treaties. I turn now to the Beijing Treaty. The purpose of copyright is to encourage writers and artists to produce the creative works that enrich our culture. And the thrust of the Beijing Treaty is to shore up against the limited protection currently afforded to performers under the Copyright Act. The Copyright Act defines performers currently as singers, musicians, and other persons who sing, deliver, declaim, play in, or otherwise perform literary and artistic works, and performance has a corresponding meaning. But that definition did not include actors or dancers, and it did not include expressions of folklore. Further, when the activity involves a literary or artistic work, then it's a performance. But if it didn't involve such a work, you might think it's a performance, but it might not qualify for protection. Now, there is no doubt that our singers and poets are performers, and there can be no dispute that dancers and actors should also be regarded as performers. But what about persons engaging in religious ceremonies and rituals? The anchor to a news station when reading the news. Stand-up comedians. Sportsmen are excluded because sports events are not literary or dramatic works. But then you have wrestlers who act out scripts. So there were all kinds of nuances and questions, and different jurisdictions have come up with different yardsticks and solutions. But if you look at what we've done in the amendment is that the definition of performer has been expanded. And to answer Senator Mark's question, yes, comedians are now part of that definition. What the Beijing Treaty does is it provides a baseline, and it will expand on the current definition of performer. Now, why were performers not treated the same way as copyright owners under the legislation? Historically, in the way European and British law evolved, the protection for performers was weak. In fact, Christianity was originally hostile to theater. No devout Christian would attend a performance, and to be an actor was forbidden on pain of excommunication. For hundreds of years, the only providers of drama were jugglers and minstrels. Performers and actors were treated as outcasts, whereas authors were afforded high cultural status. Performers were treated as less deserving of protection. Indeed, Adam Smith cited players, buffoons, musicians, opera singers, and dancers as examples of unproductive labor. And those attitudes were reflected in the law. So in today's world, where performers are now regarded as icons, stars, and they're afforded celebrity status, the law is now playing catch-up. The subject matter of the protection of copyright does not include performances, and the Copyright Act does not confer any copyright or other proprietary rights or ownership on a live performance. Performing artists such as singers and musicians are usually hired to perform their services and will usually have no copyright in the work or in the mechanical reproductions of the work. Now, WIPO laid a foundation in the late 1990s for the economic rights of performers where their live performances were fixed in sound recordings. Not copyright, but neighboring or related rights against the unauthorized exploitation of those live performances. And in particular, the exclusive right to authorize or prohibit broadcasts, recordings of their live performances, and reproductions of recordings of those live performances. But the rights of performers under Section 21 relate to oral performances only, again, A-U-R-A-L. And they do not extend to audiovisual fixations, such as film and motion pictures. Now, that's a serious gap. That's a real failing, given that in the 21st century, audiovisual works have become just as, if not more, important in an age where fans expect a multimedia experience that is increasingly audiovisual. So long story short, the amendments of the Copyright Act occasioned by the Beijing Treaty will protect and promote the economic rights of performers for their performances in audiovisual fixations. It makes clear that performers are also protected under Section 21 when their live performances are being broadcast or otherwise communicated to the public, for example, by way of streaming. And additionally, the moral rights of performers will now be closer in line to the moral rights of authors. The Beijing Treaty also requires states to provide legal remedies against the circumvention of technological measures used by performers or the producers of sound recordings in connection with the exercise of their rights, and against the removal or alteration of information, such as data information identifying an author, a performer, the performance, the sound recording, and the audiovisual fixation, which is necessary for licensing, collection, and distribution of royalties. So, in summary, the Beijing Treaty necessitated a number of amendments of the Copyright Act, including new definitions for audiovisual fixation, technical means of protection, circumvent technical means of protection, and TMP circumvention devices. We have expanded the definitions for performers and communication to the public. The expanded exclusive rights for performers and the term of protection, and the measures and sanctions for offenses involving circumventing technical means of protection and the use of TMP circumvention devices for commercial purposes. Oil and gas has served our economy well, as has the manufacturing sector. But our greatest resource, even though largely untapped, has always been and remains our human capital. Industries based on copyright and related rights have a considerable impact on national economies. Pan, calypso, soca, chutney, mass, writing, filmmaking, all these creators should be major players in terms of their contribution to our GDP, employment, and foreign trade. One antidote to the fourth industrial revolution, which is likely to make many of the conventional jobs redundant, is our creative sector. But as technologies change in the digital era, we need to keep pace and adapt. Many of our citizens have disabilities which prevent them from reading standard-sized print. And since book publishers rarely make books available in large print or braille, that has created what has been referred to as a food famine, the book famine. These amendments will allow the visually impaired access to a greater range of reading material. All of us have experienced the avalanche of emotions and excitement a powerful performance can bring. Performers make songs, poetry, stories come to life. Through them, words and ideas are given form and meaning. So it is only fair that their performances are protected, that they should be able to control the uses that are made of their performances, and that they should be able to get equitable remuneration for use of their performances. Those are the objects behind the amendments to the Copyright Act, and I think they will redound to the benefit of all society. Madam President, I thank you.
Honourable Senators, before I proceed to call on the next Senator, permit me to revert to item 3 on the order paper. We are now in receipt of the instruments from Her Excellency. The Constitution of the Republic of Trinidad and Tobago by Her Excellency Paula Mae Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Augustus Thomas. Whereas Senator the Honourable Paula Gopi-Schoon is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Augustus Thomas, to be a member of the Senate temporarily, with effect from the 12th of May 2020 and continuing during the absence of Senator the Honourable Paula Gopi-Schoon by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 12th day of May 2020. To Mr. Larry Lala. Whereas Senator Khadija Amin is incapable of performing her duties as a senator by reason of illness. Now, therefore, I, Paula Mae Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Larry Lala, to be a member of the Senate temporarily, with effect from the 12th of May 2020 and continuing during the absence of Senator Khadija Amin by reason of illness. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's this 12th day of May 2020. Honourable Senators, Senators are required to take the oath.
I, Augustus Thomas, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
I, Larry Lala, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago, upon which I am about to enter.
Senator Obika.
Thank you, Madam President. Copyright and protection, the creative industries, the Rome, Beijing, Marrakesh treaties. What is it like to be a creative in Trinidad and Tobago, where we claim to have the greatest show on earth, but the producers of that show are ostracized, are exploited, suffer for their craft? We've come a long way from panmen being beaten by police in the colonial era, but we still have a long way to go. I want to start with the World Intellectual Property Organization, and I want to say that we are grateful as a country to have the contribution of Senator Vieira. And we are at a crossroads in Trinidad and Tobago at this point in time. And when you look at the educational material and collective management of copyright and related rights, the management of copyright and related rights in the field of music, this was a document published in 2012, August 30th, by the WIPO regarding the legislative framework. They indicated that it is the job of governments, and I quote, "It is the job of governments to provide an adequate legislative framework for the enforcement and management of copyright and related rights. Without such a framework, CMOs simply could not function. Although copyright and related rights are national in scope, they are clearly international in terms of applicability and the ability of rights holders to exercise their rights." And then I jumped to an article on Loop TT on Tuesday, 12th of May, 2020, this year. So it's an article from, my apologies, on the 18th of February, 2020. It was only printed today, that's why. So the 18th of February, 2020, the headline is "Copyright Confusion. COT warns creatives, promoters." So you can very well imagine being a creative in this country, whether you are a writer, a producer, a publisher, a broadcaster, a FET promoter, or I dare say a FET goer, you would be horrified by COT warning creatives and promoters. But to draw the connection to the WIPO legislative guidance, I want to go to the conclusion of the article, where John Arnold, the head of COT, is saying there is no war, in referring to TTCU, a collective management organization responsible for advocating and collecting the royalties on behalf of rights holders in this country, as well as COT, saying there is no war. We just need to have a regulatory framework. We have written to the Intellectual Property Office asking them for that. Arnold encouraged promoters and artists to ensure they understand that they may require multiple licenses to carry on their events, as it is not a one or the other type of situation. I want to say that this legislation, though important, does not solve this problem. I am speaking for those who cannot speak. I myself have been involved in the arts for a very long time, right? From writing calypsos to judging calypsos to being a storyteller, representing Trinidad and Tobago as a storyteller in the United Kingdom, as well as in Trinidad and Tobago. teaching the art form of spoken word in Point 14 and across the National Library system in this country. This legislation falls woefully short of solving that big rift that is not producing goodwill, it is not encouraging creatives, and the government should look to providing these regulations that are being called for by none other than the head of COT. It is also being called for by TTCO, another collective management organization. Then Awesome is another organization, but Awesome, however, doesn't have members per se. It's a company structure. In the absence, so what I'm basically saying is in the absence of the heeding of the WIPO's guideline on legislative regulations, we are falling short. So when we look to the bill before us, and we take the spirit of the contribution of the Attorney General, we are saying that this bill is well-meaning. It is well-meaning. And I take heart in the contribution of Senator Vieira, because you turn to the first clause. Sorry, the first clause, in fact, in the preamble of the bill, it mentions the Marrakesh Treaty. If we turn to clause 3, it speaks to the definition of broadcasting. The Attorney General spent some time explaining why that is important in this time, given the change in what was traditionally seen as a one-horse broadcasting environment for visual works, for example, TTT, and a few radio stations, to the plethora that we have in front of us. I want to say, however, that there are other issues that need to be addressed, and I will point only to one. What is the purpose of this legislation? What is the purpose of the reciprocal agreements that we have? What is the purpose of a COT that collects rights on behalf of international institutions, international rights holders? We need to ensure that our creative industry development is in sync with our legislative procedures. What is our creative and cultural industry? Senator Mark pointed to that great economist, Vanessa James from Tobago, who spoke of, who does a lot of work in this industry, along with another economist in this industry, Professor Keith Nurse. And we have a young researcher, also a lecturer at the University of the West Indies, Dr. Karen Niles, my colleague from my undergraduate days. There is need to focus our legislative fixes to building the industry. Does it strengthen the capacities of the human resources? If it does not fix the fight between TTCO and COT, we have work to do. Does it promote competition and innovation? Does it develop internal and external markets? When you have a fight between your collective management organizations in this country, what it does, it disrupts the international relationships we have with foreign collective management organizations, whether they be in Jamaica, Barbados, Nigeria, where you have 4 Trinidad and Tobago-styled carnivals. We cannot afford to have too much disruptions in our cultural industry. Now, I want to commend a certain aspect of this legislation because myself, I would have benefited from it, being a storyteller and being someone who prepares persons to be in the spoken word arena. I believe that I believe it will help and it will go a long way. Now, there's an issue regarding the spirit of Section 21 of the Act, I believe it is, which speaks to performances, which is amended by way of Clause 7. And Clause 7 seeks to include aspects of, I believe it's the Rome Convention. Let me just double check that. So, Section 21, Madam President, may I ask how much time I have left? Or what time I might end?
You finish at 20 minutes past 12.
Okay, thank you very much. So, Section 21 of the Act seeks to include aspects of the Rome Convention, I would assume. The issue, however, would be whether or not it has been done to our satisfaction. This is a question that I guess, had I had much more time, I would have placed those questions before Senator Vieira to see if he was comforted by the style of the law and if it fits the requirements of our performers. I can't do that from the floor, obviously. It is not a fair question to pose at this time, but it's a question that I will continue to pose after this debate has ended. Because that question, Madam President, it raises other issues that arise in our cultural and creative landscape. I want to give an example. One of the key challenges with the live performances and the fetes, parties, and events that we have, you have bodies trying to determine which rights holders are to be paid by DJs, by singers, and so on, before the fact. And then you have a differential scheme in terms of how much you pay COT, how much you pay TTCO, which leaves promoters in a state of disarray. A solution to that can be you have preset fees that are agreed to by all, set in regulations that support the law. So I'm calling for some detail where that is concerned. Just as someone who is going to have a bar, in effect, they don't have to, it's not guesswork where a bar license is concerned. It matters not if they're going to sell all the inventory at Carry Brewery or if they're going to sell one bottle of rum. It should also be some level, there should also be some level of predetermination regarding the fees that promoters, because if we have to build an industry, if the spirit of this legislation is to help us build a creative industry, then the creative industry entrepreneurs should have some level of predetermination and some ability to predict what their expenses should be. So why don't we pursue, and I pose this not for response immediately, for persons such as Senator Vieira to say, why don't we look at a system where there's a playlist after the fact? And if, in fact, a rights holder should have been paid, they are covered already. If they were not played, then there are to be refunds to the promoter and so on. A scheme that balances the rights of the promoter, that balances the rights of the rights holders. And not a scheme that is balanced only in favor of one or two collective management organizations. Now, there's another aspect that I would have liked to see. I know maybe I missed it, so I guess the Attorney General could indicate if it was captured, is that COT has international agreements. They have entered the fray of neighboring rights. And if there are any impacts that are important for a legislative process, how in fact that can impact our industry here locally, and if we can get some clarity regarding that, it would be important for the Attorney General to give some wording as to exactly how Section 21 of the Act is impacted positively by the Rome Convention, so that we can have some clarity there. Now, a creative industry, I want to close my contribution by making an appeal. An appeal for a greater focus and emphasis on the creative and cultural industry in this country.
Senator Obika, you have 5 more minutes.
Thank you very much, Madam President. I want to close my contribution by making such an appeal in a manner where we can look at the opportunity for creatives to be employed. We have carnivals across the world that are patterned after the Trinidad and Tobago model. The NCBA was instrumental in that at that time, at least when they were the preeminent Carnival Band Association. Why not capitalize on that? Why do we have cultural and creative workers unemployed outside of the carnival season locally? Why do we have wire benders unemployed? Why do we have mask makers unemployed? Why do we have steel pan players unemployed? There was a pan side that went to Nigeria in Calabar Carnival some years ago, and the poorest paid player for 3 weeks' work was remunerated with 5,000 United States dollars. The poorest paid player. I can't tell you how much Len Bogsy Sharp earned and Professor Fillmore, rest his soul. So you can imagine that there is a market for what we have here in Trinidad and Tobago. But it requires a framework, a legislative framework, where we get the copyright issue right in Trinidad and Tobago. I think this legislation carries us further. I have personally benefited from this as someone who is involved in spoken word. So it's not I'm not involved necessarily in music. So the Copyright Music Organization may not capture my works. And many persons who are involved in this arena have benefited from this legislation. And we are thankful. And that is why in the opposition we support the legislation. So the government should chalk this up as a bill that the opposition is in support of at this time, but we are saying that we can carry it further, and further in the framework of a cultural and a creative industry, so that Trinidad and Tobago can no longer have a scenario where we have thousands of unemployed cultural and creative workers. And this is the plea I make to this Parliament and to the people of Trinidad and Tobago. I thank you, Madam President.
Senator.
Thank you, Madam President, for recognizing me for the opportunity to contribute to this bill entitled An Act to Amend the Copyright Act, Chapter 8280, to give effect to the Marrakesh Treaty to facilitate access to published works for persons who are blind, visually impaired, or otherwise print disabled, and to the Beijing Treaty on Audiovisual Performances. Let me start by saying I have a declared interest. My mother, who just turned 90 on the 16th of January, is a vibrant, one of the most intelligent, if not the most intelligent woman I've ever met, engaging, politically and socially active 90-year-olds that you'll ever meet. She is a retired nursing instructor in obstetrics and gynecology, and I got my wit for word and love for reading from her. She is now, however, very active, but sightless, blind. She wasn't born blind, but she became blind due to glaucoma. And this bill and its intention, because she is still such an avid learner, will assist her and the over 60,000, 70,000 persons who are visually impaired or blind in Trinidad and Tobago. So, like the speakers before me, there's very little in this bill to rebel against and not to support. I have a few comments that, of course, I'll make in terms of concerns. But this kind of legislation, to me, is very noble, because this is a world that does not generally recognize inequities and persons who are differently abled and persons who have special needs. And because of this, many in society are left at significant disadvantage. And these disadvantages are usually taken for granted by most in society, because the issues experienced by persons with disabilities and persons with special needs are not in many cases ever recognized or acknowledged or accommodated for from society at large. As the old adage goes, he who feels it knows it. I don't expect everyone to appreciate the importance of this bill in a very specific way, because it provides one more step in the long journey to equality and equal access to something most of us take for granted: books, published material, published works, which significantly adds value, opportunity, and richness to many lives in Trinidad and Tobago. Now, I reference my mother, who is 90 years old, but there are many young children under the age of 10, teenagers, persons who are young adults, 20 years old, 30 years old, persons in all age spectra in Trinidad and Tobago who are visually impaired, in many cases who are blind, for whom today is a red-letter day for their equality in Trinidad and Tobago. Access to published material in formats that make them accessible to persons with disabilities and special needs is an imperative for improving the quality of their lives and their access to information and education as enshrined in our Constitution. This bill and its intentions and provisions breathes life into daily practical experiences of persons with disabilities and many aspects of our enshrined rights in our Constitution. This is a rights issue and an equality issue. And today, presuming this very important bill is passed, we make a giant step toward realizing our credo: every creed and race finds an equal place in Trinidad and Tobago. Now, it may seem idealistic, but on a practical, daily level, many people do not experience this noble virtue as we have as part of what we aspire toward in Trinidad and Tobago. Take, for instance, the 11 aspects of our enshrined rights. The right to equal treatment from state institutions. State institutions provide many services to Trinidadians and Tobagonians. And with this, many persons who would have been disadvantaged in this enshrined right will now have that equality. The right to education. Under Section 4F of the Constitution, all parents and guardians have the right to provide a school of his or her own choice for education of his child or ward. But does that child have access to material that is accessible to them if they have a visual impairment or disability? The right to freedom of expression. If you can't read, you can't adequately express yourself in many instances because you don't have access to information. So the provisions in this bill are really fundamental to those persons who are visually impaired, blind, or have those disabilities or others, to access what many of us take for granted on a daily basis in Trinidad and Tobago. And you know, the interesting thing is, when you look around this honorable chamber, I think 70% of us wear some sort of reading aid or spectacle. Even the younger ones amongst us. Those who are not wearing spectacles have contact lenses or may have had laser intervention surgery. So we are all impaired in some way. We are not impaired to the point where it impairs our ability to access the millions and millions of books or educational aids or art and culture that's available to us, but we are impaired. But not to the extent that many are, and this bill and the provisions in it seek to close that gap, which I think is extremely noble. The Immaculate, and I just want to, before I go on, thank, because it would be remiss of me not to do that. Since I met my colleague on the independent bench, Senator Vieira, he has been such a strong advocate and supporter of IP, intellectual property. He really loves to get involved and engaged in. And I think his work on this must be commended because he's been working on this assiduously for a long, long time. So congratulations and thank you, Senator Vera, for your sterling contribution in this instance. And certainly to the Honorable Attorney General and his team for bringing this to the Parliament in this way and this time. Think of, for instance, the fact that under the COVID-19 restrictions, there are so many young people who are trying to access education online. And they are thwarted in many instances because they are visually impaired, and we take for granted that, and this will give them the ability to access many of those works in different accessible forms, something we take for granted because we have the primary gift of sight. And the Marrakesh Treaty in Action, which is called the Accessible Books Consortium, of course, aims to increase the number of books worldwide in accessible formats, braille, audio, larger print, which I need sometimes because I'm so happy with this iPad, I can increase the print size and leave my spectacles on the desk, available to persons who are blind, visually impaired, or otherwise print disabled. Now, the interesting thing about this is that it also raises many other issues in terms of Article 7 and the technological protection measures and their sorts of digital padlocks that publishers and sometimes blind persons organizations themselves put on a digital book. I understand there were some concerns recently raised when quite a noble intention, and I don't know if it's actually accurate, by the Education Ministry, which uploaded some books online for students in this time of COVID, so they have access to learning materials, may or may not, depending on what the actual information is, may have breached some sort of copyright law, and I don't know if it's true, but it's a practical reality. In the rush to provide the access to younger persons, particularly in primary and secondary schools, not all the permissions may have been sought and granted, and that's a practical example of how important observing copyright issues and laws are. Now, I know the Honorable Attorney General, and Senator Vera spoke a bit about the issue of broadcast, and I really have a concern about it because in my own field, I've had to deal with instances where there is a lot of gray area on whether or not this definition of broadcast really includes the issue of streaming comprehensively because of the digital age in which we exist. And I know in particular in radio and television, there have been many legal issues brought to the fore in terms of what is allowable in terms of streaming of content, many of the different formats that have been described earlier on by earlier speakers, whether they reside in this jurisdiction with the rights holders, the rights creators, whether it can be translated naturally by the understanding of broadcasting in this instance, where we include the Beijing Convention or the Beijing part of this act, and whether we have covered all our bases where this is concerned, because when you have the advent past terrestrial radio, of no radio streaming online to other jurisdictions, commercial content ending up on those streams, and also, let me just finish my thought, and also the issue of XM radio and satellite distribution in various jurisdictions, quite a number of issues may arise. And I know the broadcasting definition here is described as the communication of visual images, sounds, or both to the public in any country or territory by wireless transmission, including transmission by satellite, and includes an encrypted transmission where the means to decode the transmission has been provided by or with the authority of the person making the communication, and broadcast has a corresponding meaning. Now, I know in an official sense, and Senator Vera has this sort of bit of intervention, it may cover it, but when you think of the new world, and many spoke about the many creative products and services that we offer in Trinidad and Tobago, and the limitless potential that has in terms of the creators and rights owners and their rights to gain economic benefit and moral benefit from those. Imagine in our context when we were allowed to fret long ago in a galaxy far, far away. We don't know when that's going to return. And you have 5,000 people in a fete, each with a cell phone, taking a performer's work. I don't know that paying to go to the Fed naturally grants you access to tape and or stream that content around the world on social media platforms. And I don't know that this actually covers those issues effectively. Senator Vera.
Thanks. That is dealt with under the communication to the public. So besides broadcasting, that is treated as a communication to the public, the streaming.
Thank you. What I will accept your intervention, I want to quote an article that's published on May 17th, 2019 by Aditya Vyada. And it's based in India, are streaming services broadcasters. And they also brought into the discussion in this article the issue of Alexa play Machel Montano, or Alexa play Shadow, or Alexa narrate a book by Derek Walcott or a book by Senator Anthony Vera. And if that is covered under the provisions as described in this bill, and that is where I'm going in terms of how wide we need to be thinking where modern technologies and access to content are concerned. And in this particular case, the issues were brought strongly to the fore. And another case I'll cite, live streaming caught in the copyright net by Zoe Schulter, PLC. And the dispute involved TV Catch-Up Limited, TVC website, providing live internet streaming of UK television programs. A group of national UK broadcasters, including ITV, Channel 4 and Channel 5, claimed that TVC was infringing copyright in their broadcast of films and other content. And the ECJ's decision was the meaning of communication. In their ruling, suggested there's no exhaustive definition of communication to the public, and it was deemed in this ruling as a breach. But are our laws in harmony with this? And that is, to me, the question we have to answer, especially when we think of what many of the speakers before me have cited as the vast, infinite, limitless potential for monetizing and diversification of the economy. That word again, in terms of the creative sectors. When we think of Trinidad and Tobago, books, music, movies, TV shows, mass, pan, chutney, gospel, pop, rock, reggae, live performances, which we have perfected in Trinidad and Tobago in terms of the environment and the ambience, fashion, food, chemical molecule creation, technology, ideas, processes, innovation, genetic modification, strains of marijuana and their derivatives. Have we covered all those bases effectively in this? So that, to me, is where my concerns lie. With the exception of that, it is very difficult to find any egregious points in this bill, and certainly its intentions. Another article I'd like to cite in closing is from McKee, Voris, and Seas PLC, IP legal considerations for live streaming. And in many of these articles, I would have researched.
Senator Richards, you have 5 more minutes.
Thank you very much kindly, Madam President. There seems to be a lack of cohesion or harmony in various jurisdictions treating or understanding of the differences between what we have come to know as broadcasting vis-a-vis terrestrial broadcasting, radio and TV, who, by the way, all have streaming of their content now generally in some way, form, or fashion. But the use of that by individual persons when licenses and concessions only apply to X and Y. I'll tell you, I know TAT has the Telecommunications Authority of Trinidad and Tobago, has quite a lot of work on its hands when it comes to evolving our Telecommunications Act in Trinidad and Tobago to take into consideration these new paradigms, because I know for a fact it is silent in many of these issues, and that has to be dealt with if we are to deal effectively with the issues of copyright, IP, patents, etc., particularly where works of culture, arts, and the services provided by them are concerned. So the article I cite is legal considerations to live streaming, and many of the issues in terms of the overriding topics that they cited, including copyright issues in streaming, trademark issues in streaming, the right to publicity or the right to privacy, and also when that's tied into a recording industry or a broadcast industry in a jurisdiction, many of the issues that arrive are complex issues that have to be dealt with. But in conclusion, I certainly have no hesitation in lending my full support to this bill. I commend the Attorney General and his team and the government, and also to Senator Vera and the work that him and his team have done in getting it to this position, and in particular because it relates to persons with disabilities, impairments, visual and otherwise in Trinidad and Tobago. To me, it is a red letter day, and I commend you all for your good works, and I thank you, Madam President.
Minister of Agriculture, Lands and Fisheries.
Thank you very much, Madam President. Thank you for the opportunity to speak on this bill, which seeks to amend the Copyright Act, Chapter 8280. Madam President, let me take the opportunity to welcome my former classmate and the former classmate of the Honorable Attorney General, Senator Larry Lala. I always wondered if we'd ever serve in the Parliament together, and today is that day. It gives me a good opportunity, Madam President, to talk of my sometimes forgotten life as a lawyer, and this bill is a good opportunity. In 1996, I was junior counsel when there was a lot of confusion Carnival Thursday, leading into the Carnival weekend, when on behalf of Eddie Grant and ICE Records, with instructions from Josanne Leonard and Robert Amar, an injunction was sought and obtained to stop the broadcast of Carnival activities. And the implications of that were very significant. Mr. Grant had invested a lot of money to acquire the rights in relation to music that had been created since the 1920s and 30s, in particular, the catalog of one roaring lion, the Mount Lambert Calypsonian, who chalked up a lot of big hits, and Grant saw the opportunity to preserve, acquire, and extend the life of a lot of that music by owning the rights to it. He also saw the opportunity to invest, I think for the first time, in the international broadcast of the March Gras, the Panorama Finals, and other shows, which at that time was limited to local broadcasts. And the usual characters in Carnival found grave difficulty with that. And on Children's Carnival Saturday morning, Carnival Saturday, which is one of my favorite Carnival shows, events, the children had to dance to Bottle and Spoon because there was no music to be played and no broadcast or anything like that. Tied into that, Madam President, apart from the dispute of the broadcast, was an ongoing dispute with one of my favorite Lion songs, Netty Netty. I don't want to go further than that part of it. The rest is even famous than all of us and more famous than Lion. But Madam President, it was not simple. My colleague, Honorable A.G., is a very humble person, and he wouldn't boast about his master's degree in intellectual property, but I would caution you, he has one. And when we were in law school, this was still an emerging area of the law. The LLMs in intellectual property were relatively new, and most of us ran away from it because some of us never even grew up with a television, far less some of the issues which were emerging then. Madam President, so this is a continuation of something that started a long time ago and is a very important and landmark piece of amendment we are making. So I want to make 5 points in relation to the bill. The first is, Madam President, I think it's the first debate I have been in or I have witnessed in this Parliament in which the infringement of the constitutional rights has not been raised. It's accepted. But this bill requires a special majority, and from the outset I express my gratitude to my colleagues on both benches for indicating their support. This bill infringes the constitutional rights, and Clause 2 sets that out. And it infringes simply because the creators of intellectual property, the people who write, the people who perform, the people who record, all have a claim. The people who purchase eventually, like Mr. Grant, all have a claim to intellectual property rights, and all are entitled to some return from it, at a minimum, the return of respect for their creation. We have a lot of people, a lot of artists who do not mind the performance of their works, but at least an acknowledgement. Which brings me to another famous calypso, Madam President, which I'll be very careful about, but it is the man from Sangre Grande, Scrunter. And he's really the first artist who has made noise about the interference with his intellectual property, but it was a case that is not always raised. She wants me to sing in her party for free. So sometimes it is not just the recognition in a legal sense, but the recognition in a moral sense of acknowledging that it belongs to somebody else. There's creativity in it, and sometimes it should come at a price. So the infringement in this case is something that is very, very important that we acknowledge. We are really amending the Copyright Act, which provides for respect to the owners of the intellectual property, respect to be paid, and of course the appropriate cost and so on. We are asking that those rights be treated in a different way, and that we are allowed to go behind those rights and convert existing intellectual property into a new format, which will allow that format to be accessed and used by persons who are blind, visually impaired, or print disabled. I must confess, Madam President, when the Legislative Committee met with Mr. Surat on the various occasions, I had long thought that the word blind was politically incorrect, and he explained to me that it was very, very proper because it distinguishes between persons who have zero sight, blind persons, and visually impaired, people who are not necessarily blind or maybe not necessarily permanently, but people who have sight impairment. And then I was also introduced to print disabled, which was brand new to me. And I was very happy to be schooled in the concept of print disabled. The fact that people who may ordinarily be able to see are not able to read. And sometimes not able to read, not because they can't see, but they can't hold the thing that is to be read. And many of us, as Senator Richards pointed out, without being blind or visually impaired, sometimes the sheer work in this parliament, things become very, very blurry. And we find ourselves. So, Madam President, that's the first point I want to emphasize, that this bill, in a way that brings a benefit to a class of persons in the society, and I dare say a growing class of persons in the society, brings a benefit that requires an interference with the right to enjoyment of property, except by due process, which is a right enjoyed by all owners of intellectual property. The second point I want to make in relation to Clause 5 of the bill, Madam President, Clauses 4 and 5, is this. The bill is actually conflicting in itself. On the one hand, Clause 4 seeks to expand some rights, give rights where rights no longer exist. And essentially, it does that on the basis of technological changes and the way in which rights can be created now. So through a performance of itself is intellectual property. The recording of that performance is in itself intellectual property. And there are other associated things in relation to a performance that bears the right to be considered and treated in law as intellectual property. So in implementation, the Beijing Agreement, we are actually getting into expansion of existing rights, and that expansion takes place in Clauses 7 and 8. But, Madam President, as I've said, Clause 5 does the opposite of that. We are depriving somebody of a right because Clause 5 is where the bill introduces the process by which the intellectual property of a creator could be overridden in the changing of a format which is usable by blind, visually impaired, or print-disabled persons. The third point I want to make, Madam President, and it's something we've not addressed, but I want to draw to your attention, both in the definition sections, the new definitions which are being inserted through Clause 3, E, the definitions of circumventing technological protection measures, the definition of technological protection measures, the definition of technological protection measures circumvention device. Now, Madam President, to some people this means nothing. Depending on your age, you use it, and in some cases, you have no use for it. But younger people in particular spend a lot of their time looking for ways in which the protection of intellectual property can be circumvented. And it starts with the word pirate, and it comes right down the range, ending, in my world, ending right now with Fire Stick. So we understand that the protection of intellectual property is important, and we understand that there exists, using the technology, devices which allow us to circumvent the existence of intellectual property rights. And this bill, very importantly, introduces, via Clause 9, offenses relating to those devices which allow us to circumvent technological protection measures. And in fact, the bill creates criminal offenses in relation to circumvention. So this is not merely a bill which gives the opportunity to convert existing material into a format to be used by blind, visually impaired, or print-disabled person. It is also a bill that addresses this issue of circumvention and the way in which devices can allow us to get around restrictions. And in getting around restrictions, we avoid the need to pay things like royalties, to pay things like user fees, to pay things like monthly cable bills, and that those things which ultimately find their way into the hands of the owners of the intellectual property through various mechanisms, including copyright organizations. So Clause 9, Madam President, and the definitions which are proposed in 3E are very, very important in support of creating new criminal offenses and defining the components of those offenses, having particular regard to the way in which the technology allows us to do things that were not possible when we first crafted the Copyright Act. Madam President, the fourth area I want to point to is the new and expanded, what I call the new and expanded offenses in 11 and 12, and those section clauses 11 and 12, the new and expanded offenses. And again, they go beyond what is the area of focus we've had so far. I want, Madam President, on the issue of circumvention and the offenses created and the new definitions to make this point, and that is that when you look to Clause 5, Sub 5 of the bill, you would see that notwithstanding what we have introduced in the bill regarding circumvention, you would see there is a protection in this Clause 5, Sub 5, which allows, in other words, it allows for the circumvention in order to take an existing format and convert it into a different format. So take a printed format, a traditional print format, and convert it into a Braille format, or convert it into an audio format without the permission of the copyright owner. It requires technology and it requires circumvention technology. So ordinarily, that will be an offense under this amendment. Clause 5, sub 5 makes it clear that for the purpose of carrying out the activities permitted by the contents of this bill, the use of a technological protection measure shall not be treated as a commission of an offense. So while we've addressed, on the one hand, the technological devices that allow us to circumvent
Minister,
and
you have
deprive.
5 more minutes. 5 more minutes.
Thank you very much, Madam President. This bill also contains a protection in relation to what we've set out to do. Madam President, I'm very grateful to my colleagues for their support. I'm very grateful to the Attorney General for bringing this bill onto the order paper and having us dedicate the time. I asked the Honorable AG that we do it early in the day while we are fresh and we are not in a hurry, and we are able to debate it fully and consider all the amendments provided, and we are not rushed. And I am happy that we are heading in that direction, and I thank you very much, Madam President.
Honourable Senators, at this juncture, the sitting will be suspended. We will resume at 1:30 p.m. Senator Sobers will speak on the resumption.